So I might get started. Looks like most people have come into the room. There may be a few more that join us during the presentation. But thank you everybody for joining us today in this briefing on our proposals for registration reforms. It's lovely to see so many of you today. We've turned your cameras off and muted your microphones as we're recording the presentations this morning, and then we'll be able to share those the recording of the presentations on our consultation website in the next few days. If you need any technical help during the briefing this morning, you can email events@officeforstudents.org.uk, and I think the team will pop that email in the chat as well, and they will be on hand to try and help you. We've had quite a few questions submitted prior to the briefings this morning, so thank you very much indeed. And we'll answer as many of those as possible at the end of the presentations. But also you can pop your questions into the Q&A function during the presentations as well. And as I said, we'll try and cover as many as possible. If your question isn't covered that you think you've submitted, it may be that we're wrapping a few questions together, so you might not hear it in the same words, or we've had duplicate questions. But if you think it's not been asked, as I said, pop it into the Q&A, and we'll be creating a Q&A fact sheet at the end as well for any questions that we've not been able to answer this morning. We won't say who the questions are from when we ask them, but your name will appear in the chat, so just to be aware of that. And just to let everybody know, we're not able to answer questions about any individual provider or case-specific scenarios today, or the reasons for the pause in accepting new registration applications. We'll be sharing the website link to where you can find more information on that. We've also had a couple of general questions about LLE, so we don't, unfortunately, have a policy colleague here today. I think we'll ask one of the general questions, but if they're more specific, then we'll take them away and we'll come back to you with some answers directly. In a moment, well, in a very short time, I'm going to be handing over to Philippa Pickford, our Director for Regulation, and then we'll also hear from Abby Coveney and Kat Pinder, who will talk to you about the proposals for our new initial conditions of registration C5 and E7 and the changes in our registration process as well. So over to you, Philippa.
Fallen at the first hurdle, forgot to come off mute, so apologies for that. Thank you, Gail, for the introduction, and thank you everyone for joining us here today. As Gail said, my name is Philippa Pickford and I'm the Director for Regulation here at the Office for Students. I'm just here for the first part of the briefing this morning, and I'm going to be talking to you about why we are proposing the new conditions and what we are hoping to achieve as a result of implementing them, subject to decision. Unfortunately, I'm not able to stay for the Q&A session, but I will be leaving you in the capable hands of my colleagues Kat and Abby, who are the leads on this really important piece of work. So if we move to the first slide, as I'm sure everybody here is aware, we're consulting on proposed changes to our regulatory requirements for providers who would like to join the Office for Students register. We want today to give you a really clear picture of why we're making those changes, as well as what the proposed changes are. As I'm sure you've all seen, we're proposing two new initial conditions, C5 that would relate to treating students fairly, and E7 which would be relating to effective governance arrangements. And we're also consulting on changes to our registration application requirements as well. Overall, this kind of package of measures is aimed at ensuring that newly registered higher education providers are prepared to treat students fairly and are well governed. We move on to the next slide. So students have told us that they want to receive a high quality education that reflects their financial investment and the experience that they were promised, and they want to be treated fairly. And we want well-governed, innovative institutions that are currently unregistered or new to higher education to be able to enter the sector really smoothly. That's really important in terms of building the diverse higher education sector that can provide choice and real opportunities for students as well as innovation. When the Office for Students was created, most universities and colleges seeking registration had been well-established institutions with a really long track record of delivering higher education. And that's different to the applications that we get today, which tend to be from organisations that are much more new to higher education and new to regulation, and indeed sometimes to the sector as a whole. Our experience is that the current conditions of registration are not always well suited to their circumstances, and that around 40% of applications that we get in at the moment do not comply with our registration guidance when they're submitted, which can lead to a very long backwards and forwards kind of process as we're trying to get the right information in from providers. In the light of the current context in the sector, which is the increased financial challenges, and we've seen increased risks around protection of public funding and risks to students in that can be related to that, and changes to the higher education sector more generally, it now does seem that it's the right time to be reviewing our conditions of registration. So if we move on to the next slide, just sets out our aims for this, what we're trying to achieve through these proposals. We're aiming that these proposals would allow us to quickly but fairly refuse lower quality applications so that we can focus our resources on applications from well-prepared providers, that's quite hard to say, that will bring benefits to students and the sector. We're aiming to ensure that public funding is used appropriately, and we're aiming to reduce burden on well-prepared providers. We're doing that by trying to align information that we're asking providers to produce under these new conditions as far as possible with information that we'd expect providers that are well prepared to have in place anyway. And we're providing flexibility where we can in terms of how that information is provided, to enable people to be able to submit things that they've already got rather than create something bespoke for us. The changes to our registration process are also aimed at ensuring that the requirements to providers are clear and create incentives for them to submit complete high quality applications that enable us to assess them efficiently, reducing time in the queue for other well prepared providers who are wanting to register with us, which is really important. We're going to go into these proposals in a lot more detail, and I'm going to hand over to Abby now, who's going to be focusing in on the new conditions, so the conditions around treating students fairly and effective governance, and then Kat will take us through the changes to the registration processes after that. Over to you, Abby.
Thank you. Can we move on to the next slide, please? So I'm going to start by talking about the first part of our proposals. We're proposing to introduce a new initial condition C5 about treating students fairly. As a reminder, our initial conditions are the requirements that providers must be able to meet in order to be registered with the OfS. And we're proposing that initial condition C5 will focus on how a provider approaches students' rights as consumers and how it intends to treat students if it needs to make changes to their courses. Condition C5 would come into effect when we publish the outcomes of the consultation and our response, which will be in August, coinciding with when we reopen for registration applications. For applications from providers that are already registered but who wish to change their registration category, we propose that we would communicate directly with those providers to set out the information that we require them to submit. Moving on to the next slide. As we set out in our recent strategy consultation, students deserve to receive what they are promised by their provider when they choose their course. Many students we talked to last summer expressed this as the most basic condition of fair treatment. The National Student Survey results show that most students have positive experiences of higher education. However, the growing number of complaints submitted to the Office for the Independent Adjudicator supports evidence from our insight work that not all students benefit in the way they expected. And through our regulation, we've seen evidence of unclear and unfair contractual terms and conditions, providers charging additional fees, and providers publishing misleading information, all of which can compromise students' experience of and ability to engage in higher education. So we want to make sure that we have the right tests in place at registration to provide assurance that the providers on our register will treat students fairly. Next slide, please. So what would condition C5 look like for providers? So we're proposing to require submission of a provider's student-facing documents, and I'll explain a bit more about what they are on the next slide. We would use these documents to inform our assessment alongside any other information the provider makes publicly available, for example, the information it publishes on their website. And we'll also be asking providers to tell us about any court findings relating to consumer protection law. And again, I'll talk about that in a bit more later. We think that the documents that we're asking providers to submit for initial condition C5 are those that a provider would already have in place if it's ready to be registered. And as we're proposing that we would no longer require providers to produce a self-assessment at registration in relation to the C conditions, we think this will represent a reduction in the amount of work well-prepared providers need to do to put together their registration application. Our assessment of all of this information would look for evidence of unfair treatment within these information sources based on a definition that we have proposed in the consultation. If we don't find any evidence of these unfair behaviours, then the condition would be satisfied. However, if we do find evidence of unfair treatment, it's unlikely that we would find the provider to have satisfied the condition. Moving on to the next slide. So what are the key documents that we're proposing a provider would need to submit in relation to initial condition C5? So we're saying they would need to submit their contract and their terms and conditions, and this should cover any document or documents setting out terms and conditions for these students as they relate to the provision of higher education courses, but also any services that sit alongside those that relate strongly to the student experience. We also want them to tell us to submit their policies for making changes to their courses, their complaints processes, and also their refund and compensation policies. Our initial view is that these policies are the most important in assessing whether a provider treats students fairly in practice. We would then be asking the provider to publish these documents on their website after registration, and that this will collectively be their student protection plan. So we're proposing to move away from the current approach to student protection plans because we've seen that the risk assessments that providers make in these plans quickly become out of date, which means that they don't always provide useful information for students. Additionally, we no longer rely on the provisions in the student protection plan to ensure that it's taking steps to protect the interests of students if it's facing a material risk of market exit. We have condition C4 now, which gives us a much more powerful tool to act in these circumstances. And our view is that collectively, the policies we would expect providers to publish will provide clear information for students about other events which could have significant impact on their course and their higher education provisions, such as a provider closing a teaching location or making changes to their course. Moving on to the next slide. So how are we defining fairness and unfair treatment? So first of all, we've put forward a list of prohibited behaviours, which we're proposing we would use to make a judgment about if a provider is treating students fairly for the purposes of condition C5. This list is available in the consultation document. It's there in its entirety as an annex, so you can go away and refer to that if you would like to see some of the details. But this list is based on consumer protection legislation, and we've also drawn on other guidance and our experiences as a regulator. And we're proposing that the behaviours on this list would always be considered unfair in our consideration of whether or not a provider is treating students fairly, regardless of the circumstances. Can we move on to the next slide, please? The next part of our test of fairness, we're also proposing that a provider would not be regarded to be treating students fairly if, in our reasonable opinion, it does something that brings about a likely or actual detriment to students, unless we consider that that is reasonable in all the relevant circumstances. So we would consider this in a case-by-case basis, looking at whether the detriment is reasonable in the circumstances and if there are any mitigating circumstances. The draft guidance to the proposed condition, which is included in the consultation, sets out a list of factors, it is a non-exhaustive list, but a list of factors that we would consider in determining if an action would be reasonable, including whether the action is or was necessary in the circumstances, whether the circumstances were or are in the control of the provider, and whether the provider is doing or has done everything possible to limit the extent of the detriment to students. Can we move on to the next slide, please? And the final part of our definition, our proposed definition of unfairness, relates to adverse findings. So we expect all providers to comply with consumer protection law, and we propose to take as our starting position that any provider found not to have done so is unlikely to treat students fairly. And therefore we propose that where a provider has been subject to adverse findings in relation to consumer protection law, the misuse of the term degree, or the misuse of the term university, which are all issues that we've seen with providers seeking registration, that they would then not satisfy condition C5. However, we are proposing that provider would be able to make a case that this presumption should be overturned. And the factors that we're likely to take into account when we're considering this include the recency of any findings made. So are they recent or quite historic? Whether the issues that the findings were made about were repeated or sustained, whether the findings include a view about if the provider's actions or inactions that led to the finding were deliberate, how the provider is engaged with the issue since the finding was made, and any steps it's taken to address the issue and ensure that it does not happen again in future. So that's just been a brief summary of the first part of our proposals in relation to introducing a new condition C5 for treating students fairly. Please read part 1 of the consultation for more detail on these, and we're really keen to hear your views, so we'll be giving more detail at the end about how to respond to the consultation. Can we please move on to the next slide? So moving on, I'm going to talk some more to you now about the second part of our proposals, and which relate to effective governance. So we're proposing to introduce a new initial condition E7 that would require a provider to have effective governance arrangements for the purposes of being a registered higher education provider. This would replace the existing initial conditions E1 and E2 for providers seeking registration with the OfS or applying to change registration category. As with C5, initial condition E7 would come into effect when we publish the outcomes of the consultation and our response in August. And this would coincide with us reopening for registration applications. And again, for providers that are already registered but looking to change registration category, we would communicate with them directly about the information we need them to submit. Can we move on to the next slide, please? So why are we looking at governance? Governance in the higher education sector has never been more important. And in the current context, higher education providers must be able to navigate a challenging financial landscape in an increasingly volatile, uncertain, and complex global environment. Those responsible for running providers must have the capacity and skills to navigate these challenges and ensure that their students continue to receive a high-quality education. And on top of this, it's important that providers can identify and act to mitigate risks to public funding and ensure that there's value for money for students. Although many providers seeking registration are well prepared and go on to make important contributions to the sector, we think some changes in our assessment of governance arrangements are needed to ensure that we're effective in identifying providers where this isn't the case. Moving on to the next slide. We're proposing that initial condition E7 would be made up of 5 tests, which are targeted at the issues we think are most important for ensuring that we have effective governance in the sector. And I'll talk more about these tests in the following slides. We think that our proposed changes will streamline our assessment of a provider's governance arrangements by requiring submission of a set of core documents directly to the OfS, and we're proposing that we would make a direct assessment of these documents, removing the need for a provider to carry out self-assessment of its approach and of its governing documents. We're also proposing to bring the existing requirement for the provider to produce a business plan under the banner of E7, and that we're proposing to set clear criteria for what this business plan should include. And as a reminder, we're proposing that this condition would replace the current initial conditions E1 and E2, but that these conditions would remain as ongoing conditions applying to all registered providers. So this means that means that providers will still need to make sure that their governing documents uphold the public interest governance principles and that they uphold these principles in practice. Next slide, please. So for the first of these 5 tests that would make up initial condition E7, we're proposing to change the way we assess the effectiveness of governing documents at registration. And as a reminder, at the moment, we look at a provider's self-assessment of these documents. So we're proposing that our assessment should instead focus directly on the documents relating to the workings of the governing body. We think that all the documents submitted in relation to this condition should be clearly written, they should be understandable, they should be internally consistent, and they should also be consistent with other documents that the provider uses to set out the operation of its governance arrangements. When we consider the appropriateness of these of a provider's governing arrangements as set out in their governing documents, we would make reference to the provider's size, complexity, and context. And we've sought to make the list of governing documents that we're proposing providers would need to submit as narrow as possible. And as with the approach we've taken with C5, we consider that the documents we're proposing for submission are those that a well-prepared provider should already have. And these are governing body documents, by which we mean the documents which set out the purpose of the governing body, its membership, how it appoints members, what the governing body's responsibilities are, its decision-making procedures, the frequency of its meetings, and the arrangements for reviewing its effectiveness. We would also want providers to submit any other documents that contain additional rules for the governing body's operations. So that might be a royal charter, articles of association, shareholder agreements, or a scheme of delegation. We want them to submit documents which set out how their risk and audit functions would work, and also a conflicts of interest policy. And just as a reminder, that this would mean that we would remove the current requirement for a provider to carry out self-assessment of this documentation. Can we move on to the next slide, please? The second proposed requirement is about a provider's business plan. So we welcome innovation in the sector because this is an important way of creating diversity and competition, which goes on to benefit students by increasing choice and driving improvement. And we don't intend to prevent providers from pursuing legitimate commercial objectives or strategies, even where these may carry an increased risk, nor do we want to refuse a provider's registration application based solely on the business model it's chosen to pursue. But this is provided that we can gain assurance that those risks sit with the provider or its shareholders and not with students and taxpayers. To allow us to make this assessment, we're proposing that providers must have a business plan which is, first of all, clear, comprehensive, and coherent. And it must demonstrate that the provider has a good understanding of the higher education sector, that it understands the risks to its business model, and that it sets out clearly its strategies to manage those risks, and that the provider understands the regulatory requirements that will apply to it if it's registered. We're proposing that the plan would need to cover the provider's current financial year and for future years, and that aligns with the financial information that providers need to submit at registration in relation to Condition D for financial viability and sustainability. Excuse me. It would also need to demonstrate significant consideration of the interests of students in formulating its business plan, and we would want to see that the provider can deliver its plan in practice. Can we move on to the next slide, please? Thirdly, we're proposing that a set of key individuals would need to have the right knowledge and expertise to run a registered higher education provider. We've seen providers applying for registration where the person responsible for its management and governance haven't fully understood their role and responsibilities, and this can lead to serious implications for students. We want to see that these people have the right knowledge and expertise. That means that the provider, if registered, would be able to comply with the conditions of registration, deliver its business plan, and deliver its arrangements for preventing fraud and public funds. We're proposing to apply this requirement to a limited set of key individuals that fulfil the specific roles at the provider. This includes the chair of the governing body, the accountable officer, the person with overarching responsibility for financial management, and where applicable, an independent member of the governing body. And we recognise that for some providers, it might be the same person who fulfills more than one of these roles, and that's fine. For each of these key individuals, we're set out in the consultation explicitly which matters we expect them to demonstrate knowledge and expertise in, and whether they should be able to demonstrate in-depth understanding or higher level awareness of those matters. And normally we would assess these requirements by undertaking a short interview with each key individual. And in most cases, we expect that those discussions could be conducted online. Next slide, please. Our fourth proposed requirement is that the provider must ensure that relevant individuals within its organisation are fit and proper to ensure that the provider is suitable to access and receive public funds, public trust and confidence in the higher education sector are maintained, and the provider is suitable to protect the interests of students. Our definition of relevant individuals includes a larger group of people than those key individuals discussed on the previous slide. And if the people responsible for running a provider are not fit and proper, there can be significant risks for students and taxpayers. So we're proposing to introduce more prescriptive, comprehensive rules-based requirements in this area to provide additional assurance. Providers will need to conduct their own tests and then tell us about the outcomes, and we'll review this information and decide if we need to do any additional checks ourselves. There's detailed criteria for fit and proper persons available in the consultation document, but in summary, there are two lists. First of all is matters that the OfS will consider indicate that an individual is not fit and proper unless there are exceptional circumstances. So that includes being disqualified as a company director or charity trustee, being an undischarged bankrupt, or having been convicted of an unspent criminal offence. And this is alongside a broader list of matters that we'll give particular consideration to. Can I have the next slide, please? And finally, for the fifth requirement, we're proposing that a provider applying for registration must have arrangements in place which are adequate and effective for preventing, detecting and stopping fraud and the inappropriate use of public funds, and that it must also have a satisfactory track record in relation to receiving and accessing public funds if it has been doing so. This is so that we can identify and refuse applications from providers where there are material risks in these areas, as this can have significant impacts for both students and taxpayers. So we propose to require a provider seeking registration to have comprehensive arrangements in place, including a risk register, internal control processes, a whistleblowing policy, an anti-bribery policy, fraud awareness and prevention training, and provision of reporting structures for staff responsible for these arrangements. And they must also have a satisfactory track record of fraud in relation to fraud convictions or receiving accessing public funds, which mean they must not have been convicted of a fraud offence or have had access to public funds revoked in the last 60 months. So before I hand over to Kat, please do read part 2 of the consultation for more details on these proposals. And once again, we're really keen to hear your views.
Thank you, Abby. And welcome to everybody. I'm going to talk about the final part of the consultation, which relates to the requirements for registration applications. Can I have the next slide? Thank you. So why are we making changes to registration application requirements? Firstly, if we introduce the new initial conditions that Abby has just described, this will mean that we need some different information to be submitted than we currently set out in our registration guidance. And so we've set all of that information out in the consultation. Second, as Philippa mentioned at the beginning, we really want to avoid delays during the registration assessment process. Often the timeline for a case is extended when we ask for clarifications or updated information, and we really want to reduce these delays where at all possible by enabling applicants to prepare in advance to give updates when they might be needed. And last, more generally, we want registration to be as quick and efficient as possible for providers that are well prepared and submit complete applications. And many applicants do currently get this right, but we want to be able to tackle and address some of the issues that take up time for us to resolve, including some providers making poor quality submissions and providers failing to respond sometimes to queries during the assessment process. Next slide. So the first proposal in the registration part of the consultation is to determine the requirements for an application. So we propose to set these requirements out in a formal notice, and if an application doesn't meet these requirements, it could be refused. The full notice setting out these requirements is included in the consultation in part 3, Annex A, and we'll include a link to that. And that sets out all of the requirements for a registration application. This is done under Section 3 of the Higher Education Act, which established the OfS, Section 3 of HERA. So we refer to the Section 3 Part 5 notice. What that means is the notice that sets out the registration application requirements in full. And we've also explained that if a provider were refused registration on the basis that it didn't meet these application requirements, in the first instance, that's a provisional refusal decision, and a provider gets 28 days to make representations about that decision, including providing any information that might be missing. And we would clearly set out what information was missing. The notice is a combination of information and documentation that's already set out in our registration guidance, much of which is not changing. Some new proposed requirements, which I'll explain in more detail in a second. And as I've mentioned, some of these requirements relate to conditions C5 and E7, but there are some other additional changes, which I will explain. Next slide. So proposal 2 in the registration part of the consultation talks about some additional information about finance and corporate structure. Our current registration guidance sets out that we need particular financial information. That includes financial tables in a particular format that we provide and audited financial statements for as many of the past 3 years that a provider has been in operation and delivering higher education. These requirements would remain the same. However, in light of the increasing financial challenges in the sector, we're proposing that a provider applying for registration would need to undertake some scenario modelling to demonstrate how it would remain financially viable and sustainable in an adverse, but we think plausible scenario, such as, for example, significant under-recruitment of students in the early years of being registered. We've set out some scenarios that we think are appropriate in the consultation, and we really welcome views on whether these scenarios are the right ones. We also propose a requirement for a corporate structure and ownership diagram. A lot of providers already submit this to us as part of an application, and we find that we can understand the context of a provider much more quickly and effectively when this is provided. So we're proposing to make that a requirement for everybody. And then the last element of this is about seeking updates during the process. So during the assessment process, we propose to seek a particular update on financial information towards the end of the assessment process and prior to our decision. And this is so that our decision is based on the most up-to-date financial information at the time, because clearly there can be significant financial changes over a period of a few months or a year. And then the last proposal is to require any further years of audited financial statements as they become available during the assessment process. And so the deadline we propose is 9 months after the year end. Next slide. The next proposal in the registration section is about investigations. So we have found situations in which investigations might be opened into a provider during the course of a registration application, or where there have been recent investigations that are relevant to our assessment of whether a provider satisfies initial conditions of registration. And we've not always heard about those in a timely way. We may have found out kind of later or late. We're therefore proposing that a provider applying for registration would need to include information with its application about any investigation opened or concluded within the last 60 months, 5 years. This is intended to be a broad requirement, so if something has occurred that could be described as an investigation, a provider should disclose this rather than avoid doing so. We recognise that much investigatory activity may not be relevant to our assessment, particularly anything that could constitute routine investigatory activity. So we may proceed with our assessment without requiring anything further from a provider if they disclose some kinds of investigation to us, or alternatively, we may require some more detailed information before we can proceed. And this could mean pausing an application until the outcome of an investigation is known, if that investigation is currently live. Next slide. So the next proposal is to report particular matters if they occur during the registration process. Many providers keep us well informed and up to date during the period that we are assessing their applications, but we think it's helpful to just give some fairly clear kind of rules about what needs to be notified to us during the course of an assessment. So in the consultation, we include an exhaustive list of matters that would need to be notified to us during the assessment process. So examples are sort of significant changes to governance or corporate structure, particular adverse changes to a financial position, or significant changes to sort of higher education provision. The aim of this list is very much to capture significant or material changes, but not include things that are not likely to be necessary to our assessment or change our assessment. Next slide. And then the final proposal in the registration part of the consultation is to introduce a restriction that would mean a provider could not submit a new registration application for at least 18 months following the refusal of a previous application by the OfS. The aim of this is to enable us to focus our resources on providers that meet our requirements in the first time of applying over those that don't. We are interested, though, in views on the length of this period, and we're aiming to strike a balance here between fairness for providers and the most efficient and effective use of our resources. It's also worth knowing that this proposal would come into effect later than the other proposals. So we are proposing in general that the changes would come into effect in August when we are planning to reopen for registration applications. However, this proposal we propose would come into effect on the 1st of January 2026 for new applications submitted after that date. And the reason we're proposing that this would take effect later than the rest of the proposals is because we want to ensure that the other changes that we're proposing to introduce are in place and operating smoothly before we introduce this consequence of having a registration application refused. Next slide, I think. So that's the end of the presentation elements. And we've obviously included some information here about how to find out more and how to respond to the consultation, but we'll now hand over and begin the kind of Q&A section and can hopefully answer some of the questions that we can see have come into the Q&A function.